You will learn, Mr. Price, that this court does not tolerate theatrics. The gavel cracks against wood. The sound echoes off the oak-paneled walls of courtroom 4C like a gunshot. The man in the worn gray suit doesn't flinch. He stands at the defense table, pen still in hand, notebook open to a page filled with timestamps and shorthand. His client sits behind him in a wheelchair, eyes wide with terror. Bailiff, remove Mr. Price from this courtroom. He is remanded to Harris County Jail for 72 hours. The judge's voice carries the absolute certainty of a man who has never been questioned. 28 years on the bench, hundreds of attorneys who learned to bow, to defer, to accept whatever scraps of justice he decided to throw their way. But he has made a mistake. For 3 years, every word spoken in this courtroom has been recorded, every ruling documented, every pattern cataloged and time-stamped and filed with the Fifth Circuit Court of Appeals. The judge doesn't know this. He doesn't know that the man he just sentenced to 72 hours in county jail is the same man who will end his career. The bailiff moves forward, handcuffs glinting under the fluorescent lights. The attorney closes his notebook slowly, deliberately, and slides it into his jacket pocket. He looks at his client, the man in the wheelchair whose spine was shattered by Houston police officers 18 months ago. 72 hours. Remember that number, Raymond? The courtroom doors swing shut behind him. The judge smiles, satisfied that order has been restored. He has no idea what's coming. If this satisfies you, smash that subscribe button, because what happens in those 72 hours will shake the Texas legal system to its core. 4 months earlier, the sun hadn't yet risen over Houston's 3rd Ward when Julian Price unlocked the door to his office. The building was old, a converted warehouse that had seen better decades. The elevator hadn't worked in 3 years. The air conditioning ran on prayers and stubbornness. But the rent was cheap, and the location meant his clients didn't have to travel far. His office occupied the 2nd floor, a single room with a desk, 2 chairs, and wall-to-wall bookshelves crammed with case law. A framed State Bar of Texas certificate hung above the window. Next to it, a photograph of a young man with Julian's eyes and his mother's smile. Dion Price, 1991-2019. Julian didn't look at the photograph as he entered. He didn't need to. His brother's face was burned into his memory like a brand. He set his briefcase on the desk, pulled out a French press, and began his morning ritual. Coffee grounds measured with precision. Water heated to exactly 200 degrees. 4 minutes of steeping time. While he waited, he opened his laptop and logged into Pacer, the federal court records database. His spreadsheet was already open, hundreds of rows of data stretching back 3 years. Case numbers, dates, outcomes, attorney names, demographics. He added a note from yesterday. Hollister mentioned 12% plaintiff win rate in Caldwell's court. Verify. The coffee was ready. He poured a cup, took a sip, and opened his notebook. The first page was dated January 15, 2022. 3 years of timestamps, 3 years of documentation, 3 years of watching the same pattern repeat itself. His phone buzzed, a text from an unknown number. New client referral, Raymond Colbert, excessive force case, interested? Julian stared at the message. Excessive force meant suing the police. Suing the police in Harris County meant appearing before Judge Vernon Caldwell. And appearing before Caldwell meant losing. Every civil rights attorney in Houston knew it. The statistics were brutal. Plaintiff win rate in Caldwell's courtroom, 11%. State average, 34%. The man had built a career on crushing police brutality cases. Julian typed his response. Send him my information. An hour later, the door opened. Raymond Colbert was 34 years old, though he looked older. His face carried the weight of 18 months of pain, 18 months of physical therapy, 18 months of watching the officers who paralyzed him walk free. His wife Tamika pushed his wheelchair through the narrow doorway, her expression a mixture of exhaustion and defiance. Mr. Price? Raymond's voice was rough, like he'd forgotten how to use it. I'm Raymond Colbert. This is my wife. Julian stood, extended his hand. Raymond's grip was weak but determined. Please, sit down, both of you. Tamika positioned the wheelchair across from Julian's desk, then took the remaining chair. Her hand found her husband's, their fingers intertwining with the ease of long practice. Every lawyer I called said the same thing. Raymond stared at the desk, not meeting Julian's eyes. Caldwell's court? You'll lose, but I can't let them get away with it, Mr. Price. I was driving home from work. I wasn't speeding. I wasn't doing anything wrong. And they... His voice broke. Tamika squeezed his hand tighter. Julian opened his notebook. Fresh page. Clean ink. Tell me what happened. Every detail. From the moment you saw the lights. Raymond talked for 47 minutes. Julian didn't interrupt once. He wrote in his precise shorthand, capturing timestamps, officer names, locations, injuries. When Raymond described the moment he realized he couldn't feel his legs, Julian's pen paused for exactly 2 seconds. Then he continued writing. When it was over, the room was silent except for the hum of the ancient air conditioning. Mr. Price? Tamika's voice was steady, but her eyes were wet. Can you help us? Julian looked at the photograph on the wall. Dion's smile. Dion's case file, buried somewhere in the Harris County archives. Dion's grave in Houston Memorial Gardens. He closed his notebook. I'll take your case, but I need you to trust me, even when it looks like we're losing. Raymond's eyes finally met his. What do you mean? I mean that Caldwell's court is designed to break people. He'll deny our motions. He'll sanction me for filing them. He'll make every step of this process as painful as possible. And through all of it, I need you to trust that there's a plan. What kind of plan? Julian didn't answer. He couldn't. Not yet. Just trust me, Raymond. Can you do that? Raymond looked at his wife. Some silent communication passed between them. We can do that. The Harris County Courthouse was a monument to Texas justice, all limestone and columns and flags snapping in the Gulf wind. Julian had walked these halls hundreds of times. He knew which elevators ran slow, which bathrooms were always locked, which clerks would process filings without hassle. He also knew which clerk would make his life difficult. Lorraine Ashby had worked in the clerk's office for 22 years. She was efficient, organized, and absolutely loyal to Judge Caldwell. Nothing happened in his courtroom without her knowledge and approval. Julian approached the filing window with his complaint in hand. The document was perfect, formatted exactly according to Texas rules of civil procedure, every margin precise, every citation accurate. Lorraine didn't look up from her computer. Filing for Judge Caldwell's court? Yes, ma'am. Colbert versus City of Houston. She took the document, flipped through it with the speed of long practice. Her eyes stopped on the 3rd page, then the 7th, then the cover sheet. This margin is 0.3 inches off. She slid the papers back through the window. Rule 21 requires 1-inch margins. You'll need to refile. Julian didn't argue. Julian didn't. He knew Rule 21 didn't specify margin width, only that documents be legible. But arguing with Lorraine Ashby was like arguing with a wall that reported directly to Caldwell. He took the papers back. Thank you for catching that, Ms. Ashby. I'll refile this afternoon. Her eyes narrowed slightly, suspicious of his compliance. Julian maintained a neutral expression as he turned and walked toward the elevator. His notebook was already open. He wrote, 9:17 a.m. Ashby. Margin rejection. No statutory basis. Pattern, obstruction. The elevator doors opened. A man in a $3,000 suit stepped out, flanked by 2 associates carrying briefcases. Grant Hollister, senior partner at Houston's largest firm, lead attorney for the city of Houston in civil rights cases. Their eyes met. Hollister smiled. Julian Price, another police brutality case? You know Caldwell's stats, right? Julian stepped into the elevator holding the door. I'm aware. Plaintiffs win 12% of the time. Defendants win 88%. Hollister's smile widened. Guess which side I'm on? I'll see you in court, Mr. Hollister. The elevator doors closed. Julian opened his notebook. 9:23 a.m. Hollister, 12% plaintiff win rate. Verify via Pacer. That night, in his apartment above a Vietnamese restaurant, Julian sat before his laptop and verified. The numbers were actually worse than Hollister had claimed. 11% plaintiff win rate in Caldwell's court, the lowest in Texas, the lowest in the entire Fifth Circuit. He added the data to his spreadsheet, row 247, another brick in the wall he was building. On the wall above his desk, Dion's photograph watched him work. 2 weeks later, Julian entered courtroom 4C for the first time. The room was designed to intimidate. Oak paneling stretched from floor to ceiling. The judge's bench sat 18 inches higher than the attorney tables, forcing everyone to look up when addressing the court. American and Texas flags flanked the bench like sentinels. A man stood by the main entrance, arms crossed over a barrel chest. His nameplate read W. Crenshaw, but his posture read former SWAT. Julian had researched him. Wade Crenshaw, court bailiff for 12 years, 3 excessive force complaints from his previous career, all dismissed. Their eyes met as Julian walked past. Crenshaw's expression didn't change, but something in his gaze made Julian's skin prickle. He took his place at the plaintiff's table. Across the aisle, Grant Hollister arranged papers with practiced efficiency, not acknowledging Julian's presence. Behind Julian, Raymond and Tamika sat in the gallery. Raymond's wheelchair was positioned at the end of a row, the only accommodation the courthouse had made. A door opened behind the bench. Everyone rose. Judge Vernon Caldwell emerged from his chambers like a king entering his throne room. 63 years old, silver hair immaculately combed, gold-rimmed glasses perched on a patrician nose. His robes billowed as he climbed to the bench. He surveyed the courtroom, taking inventory. His gaze lingered on Julian for a fraction of a second longer than necessary. "Be seated." His voice was deep, authoritative, accustomed to absolute obedience. "Colbert versus City of Houston. Counsel, state your appearances." Hollister stood first. "Grant Hollister for the defendant, Your Honor." Julian rose. "Julian Price for the plaintiff, Your Honor." Caldwell's pen scratched across paper. He didn't look up. "I've reviewed the complaint. Mr. Price, your motion for expedited discovery is ambitious. The plaintiff requires access to body cam footage and internal affairs records to proceed, Your Honor. Texas Rule of Civil Procedure 196.1. I'm familiar with the rules, counsel." Caldwell's voice sharpened. "Motion denied. Overly broad." Julian didn't react. "Your Honor, the motion specifically requests footage from officers Hendricks and Morales on the night of—" "I said denied." The gavel cracked. "Refile with more specific parameters. Next matter." Hollister was already sitting down, a satisfied smile playing at his lips. Julian remained standing. "Your Honor, for the record, I note that the motion complies with Rule 196.1, which requires production of documents relevant to the subject matter of the pending action. I respectfully request the court state its legal basis for denial." The courtroom went silent. Caldwell's pen stopped moving. When he looked up, his eyes were cold. "The court's basis is that the motion is overly broad. Do you have difficulty understanding English, counsel?" "No, Your Honor. I simply wish to preserve the record for appeal." The word appeal hung in the air like a challenge. Caldwell's jaw tightened almost imperceptibly. "Noted. Is there anything else, Mr. Price?" "No, Your Honor." "Then we're adjourned." The gavel fell. Caldwell disappeared through the chamber door. Julian gathered his papers slowly, giving himself time to write in his notebook. 10:47 a.m. Motion denied. No legal basis stated. Rule 196.1 violation. Caldwell hostile to appeal mention. Behind him, Raymond's wheelchair squeaked against the floor. He didn't even read it. Raymond's voice was hollow. "Is that legal?" Julian closed his notebook. "Technically, judges have wide discretion, but discretion has limits. What do we do now?" Julian looked at the empty bench where Caldwell had sat, then at Wade Crenshaw, still standing by the door, watching. "We document. We refile. We don't give up." That night, Julian's phone rang at 11:47 p.m. The number was unfamiliar. Area code 504, New Orleans. He answered on the third ring. "Mr. Price?" The voice was older, cultured, with the careful diction of someone who had spent decades in courtrooms. "This is Judge Emmett Shaw, retired, Fifth Circuit. I believe we have a matter to discuss." Julian sat up straighter, suddenly alert. "Judge Shaw, I wasn't expecting to hear from you directly. I've been reviewing your petition. The data you've compiled is compelling. 17 cases over 5 years. 89% denial rate for black civil rights attorneys in Caldwell's court. Sanction patterns that target specific demographic groups." A pause. "This isn't coincidence, Mr. Price." "No, sir, it's not. Statistics alone won't be enough. The Commission will want real-time documentation, evidence of bias as it occurs, not just historical patterns." "I understand." "Do you?" Shaw's voice sharpened. "What I'm proposing will require you to take cases you know you'll lose, to watch clients suffer while you build an evidentiary record, to endure sanctions and contempt citations without breaking cover." Julian looked at Dion's photograph. "I've already been doing that, Judge Shaw, for 3 years. Silence on the line. Then, slowly, Federal Rule of Evidence 706 allows appellate courts to appoint expert witnesses to evaluate lower court conduct. It's rarely used, but it exists for situations exactly like this. An expert witness. Court appointed. Your assignment would be to document judicial bias patterns in Caldwell's courtroom. Your findings would be submitted to the Fifth Circuit and the Texas State Commission on Judicial Conduct. Another pause. The appointment would be sealed. Caldwell wouldn't know. Julian's grip tightened on the phone. "When?" "I can have the order signed by Friday, but I need to know you understand what you're agreeing to, Mr. Price. This isn't just documentation. This is putting yourself in the crosshairs of a very powerful man." "Judge Shaw," Julian's voice was steady, "My brother lost his case in Caldwell's courtroom in 2019. 3 months later, he was dead. I've been preparing for this conversation for a long time." Silence. "Then I'll see you in New Orleans on Friday, Mr. Price. We have work to do." The line went dead. Julian set down his phone and opened his notebook. He wrote, 11:52 p.m., Shaw, Fifth Circuit, Rule 706. This is it. Above him, Dion smiled from the photograph, frozen in time. If this story has you hooked, subscribe now, because the war Julian Price is about to wage will change everything. 3 weeks later, Julian sat in a small conference room on the 7th floor of the Fifth Circuit Court of Appeals building in New Orleans. Judge Emmett Shaw was everything his voice had suggested. 71 years old, silver-haired, with the bearing of a man who had spent 4 decades dispensing federal justice. His office was lined with law books and commendations. A photograph on his desk showed him shaking hands with Thurgood Marshall. "Before we proceed, I need you to understand something." Shaw slid a document across the table. "This appointment carries significant risk. If Caldwell discovers what you're doing before the record is complete, he could bury you. Sanctions, contempt, bar complaints. He has friends on the Texas State Bar Disciplinary Board." Julian picked up the document. The seal of the Fifth Circuit Court of Appeals was embossed in the corner. "I understand." "Do you?" Shaw leaned forward. "You'll be taking cases you know you'll lose, watching clients suffer, enduring abuse from a man who has absolute power in his courtroom. And you can't tell anyone, not your clients, not other attorneys, not even your family." "My family is dead, Judge Shaw." Julian's voice was flat. Dion was the last. Shaw's expression softened slightly. "I read about your brother's case, wrongful termination suit against the city. Caldwell granted summary judgment after denying every discovery motion. 3 months later, Dion stepped in front of a metro train." The words hung in the air. Julian's face remained impassive. "That case isn't part of my documentation." He met Shaw's eyes. I excluded it specifically to avoid any appearance of personal bias. Everything I've compiled relates to other plaintiffs, other attorneys, other victims. Shaw nodded slowly. That shows remarkable discipline, Mr. Price, and it will strengthen your credibility when this goes before the Commission. He pushed the document closer. Federal Rule of Evidence 706, Court-Appointed Expert Witness. Your assignment is to document potential patterns of judicial bias in the 190th District Court of Harris County, Texas. The appointment is sealed. Caldwell will have no idea. Julian read the first paragraph aloud. Pursuant to Federal Rule of Evidence 706, the Fifth Circuit Court of Appeals hereby appoints Julian D. Price, Esquire, as court-appointed expert witness to evaluate and document potential patterns of judicial bias in the 190th District Court of Harris County, Texas. Appointment date, March 3, 2022. Sealed until evidentiary record complete. He looked up. How long? As long as it takes. Months, years, until you have enough documentation to prove a pattern beyond any reasonable doubt. Shaw stood, walked to the window overlooking the Mississippi River. I've watched Caldwell operate for 20 years, Mr. Price. He's smart, careful. He never says anything explicitly biased, never uses language that would trigger automatic review. But the numbers don't lie, and eventually, numbers are what bring these men down. Julian signed the appointment order. When do I start? You already have. Shaw turned from the window. The Colbert case is perfect. High-profile victim, clear police misconduct, exactly the kind of case Caldwell will want to crush. And when he does? You document everything, every denial, every sanction, every instance of disparate treatment. Texas is a one-party consent state. You can record every proceeding without his knowledge. Julian nodded. And when the record is complete? You unseal the appointment, present your findings to the Judicial Conduct Commission, and we watch Vernon Caldwell's career end. Shaw extended his hand. Julian took it. One more thing, Mr. Price. Shaw's grip tightened. I knew your brother. He clerked for me one summer, back in 2015. He was brilliant, passionate. He deserved better than what Caldwell did to him. Julian's throat tightened. Thank you, Judge Shaw. Don't thank me yet. Thank me when it's over. The weeks that followed established a rhythm of controlled suffering. Julian refiled his discovery motion with narrower parameters. Caldwell denied it again, citing continuing overbreadth. Julian filed a third motion. Denied. A fourth. Denied with a warning about wasting the court's time. Each denial was documented, time-stamped, added to the growing record. Meanwhile, the docket manipulation began. Julian arrived at the courthouse for a scheduled hearing on October 15th to find the courtroom empty. He checked the docket board. Colbert v. City of Houston had been moved to November 29th, 6 weeks away. He approached the clerk's window. Excuse me, Ms. Ashby, I received no notice of the schedule change. Lorraine Ashby didn't look up from her computer. System error. The notice was sent to your address of record. My address of record hasn't changed in 5 years. Then perhaps you should check your spam folder, Mr. Price. Her tone made clear that further argument was pointless. Julian stepped back. I'd like to file a Public Information Act request for the scheduling logs related to my case. Now she looked up. Her eyes narrowed. You'll need to submit that in writing. Processing takes 15 to 20 business days. Texas Government Code Section 552.021 requires response within 10 business days. Processing takes 15 to 20 business days, Mr. Price. Julian wrote in his notebook. 11:02 a.m. Hearing rescheduled without notice. Ashby refused log access. PIA request filed same day. 6 weeks of waiting. 6 weeks of Raymond Colbert living in pain. 6 weeks for the city's lawyers to prepare. All according to plan. The confrontation at the coffee shop happened on a Tuesday afternoon. Julian was reviewing case files at a corner table when the door opened and 3 men in Houston Police Department uniforms walked in. The one in front was tall, broad-shouldered, with sergeant stripes on his sleeve. His nameplate read, Pemberton. Julian had seen that name before, in Raymond's hospital records, in the internal affairs complaint. Sergeant Neil Pemberton, one of the responding officers on the night Raymond lost the use of his legs. Pemberton saw Julian at the same moment Julian recognized him. The sergeant's face twisted into something between a smile and a sneer. Well, well. He approached Julian's table, coffee forgotten. The ambulance chaser himself. How much you making off Colbert's wheelchair? 20%? 30? Julian didn't look up from his papers. Counsel fees in contingency cases are typically 33%, Sergeant. It's a matter of public record. Pemberton's smile vanished. I was there that night, you know. Your client resisted. We did what we had to do, and no lawyer from Third Ward is going to change that. Julian turned a page. I appreciate you identifying yourself as a witness, Sergeant. That'll be useful for deposition. Pemberton's face flushed red. His hand moved toward his belt, an instinctive gesture that made the other customers freeze. You think you're smart? His voice dropped to a hiss. You think your little lawsuits are going to make a difference? Caldwell's been shutting down cases like yours for 30 years. You're just another name on his kill list. One of the other officers grabbed Pemberton's arm. Neil, not here. Pemberton shook him off but stepped back. His eyes never left Julian. Watch your back, counselor. Third Ward's a dangerous neighborhood. They left without ordering. Julian waited until the door closed before reaching into his pocket and stopping the recording on his phone. His notebook was already open. 2:47 p.m. Pemberton. Threatened. Admitted presence at scene. Kill list reference. Audio recorded. Another brick in the wall. The hearing in November brought the first sanctions. Julian had refiled his discovery motion a 5th time, this time with parameters so narrow they couldn't possibly be called overbroad. He requested only the body cam footage from Officer James Hendricks between 9:30 and 10:15 p.m. on the night of the incident, a 45-minute window. Caldwell denied it. Your Honor, with respect, this motion requests a single piece of evidence from a single officer during a specific time period. There is no conceivable interpretation under which this could be considered overbroad. Caldwell's eyes were cold. Counsel, I've denied 4 previous motions on this matter. Your continued filings constitute harassment of the court. I'm issuing sanctions under Texas Rule 13 for filing a frivolous motion. $5,000. Julian's jaw tightened, but his voice remained steady. Your Honor, Rule 13 requires a finding of bad faith. I have simply refiled as the court instructed, with increasingly narrow parameters. Are you arguing with the court? I'm stating the legal standard, Your Honor. Caldwell leaned forward. $10,000. Would you like to continue? The courtroom was silent. Behind Julian, he could hear Tamika's sharp intake of breath. $10,000 was more than 2 months of operating costs for his office. Julian opened his mouth to respond. Your Honor, for the record, I note that the Fifth Circuit has held in Rodriguez v. Harris County, 2019, that sanctions require a showing of objective unreasonableness. This motion is substantively different from prior filings and addresses each of the court's stated concerns. Caldwell's expression flickered. For the first time, something like surprise crossed his features. Julian had just cited a Fifth Circuit case, the appellate court that reviewed Caldwell's decisions, the court where any appeal of these sanctions would be heard. Noted, counsel. Caldwell's voice was tight. The sanction stands. Next matter. Julian sat down and wrote, 10:34 a.m., $10,000 sanction. Rule 13, violation by court. Fifth Circuit citation caused visible reaction. Caldwell aware of appellate exposure. Grant Hollister was watching him from across the aisle, his expression thoughtful. The parking garage confrontation happened that night. Julian had stayed late, reviewing transcripts in the law library until the building emptied. By the time he walked into the garage's 3rd level, the only sound was his footsteps echoing off concrete. He was 20 feet from his car when a voice called out behind him. Long day in court, counselor? Julian stopped but didn't turn. He recognized the voice. Wade Crenshaw, Caldwell's bailiff. He reached into his pocket and pressed the record button on his phone. "Can I help you, Mr. Crenshaw?" Footsteps approached. Crenshaw appeared in Julian's peripheral vision, leaning against a concrete pillar with his arms crossed. Out of uniform now, wearing jeans and a tight t-shirt that showed off arms thick as tree trunks. "Judge Caldwell asked me to deliver a message." "I'm listening." Crenshaw pushed off the pillar and moved closer. His shadow fell across Julian like a shroud. "He says you should consider your career. A lot of lawyers burn out young in this line of work. Stress, health problems, accidents." Julian finally turned to face him. "Is that a threat, Mr. Crenshaw?" "It's friendly advice." Crenshaw smiled, showing teeth. "Take it or leave it." Julian didn't step back, didn't show fear, just stood perfectly still, his face a mask. "Noted. For the record." Crenshaw's smile faltered. Something in Julian's tone, in his absolute stillness, seemed to unsettle him. "You're not as smart as you think you are, Price." "Maybe not, but I'm patient." They stared at each other for a long moment. Then Crenshaw laughed, a harsh sound in the empty garage. "Patience won't save you, not from what's coming." He turned and walked away, his footsteps fading into the darkness. Julian waited until silence returned before releasing a breath he didn't know he'd been holding. He opened his notebook and wrote, 7:34 p.m., Crenshaw, Parking Garage B, Level 3, Threat delivered on behalf of Caldwell. Accidents reference, What's coming reference, audio recorded. His hands were steady as he wrote. They had to be. The wall was almost complete. December brought escalation. Julian's Public Information Act request finally returned results. The scheduling logs showed a clear pattern. Every case assigned to Julian's office had been moved to end-of-day slots within 48 hours of filing. His cases were systematically buried at the back of the docket, ensuring he'd face a tired judge at the end of long days. The email chain was even more damning. From V. Caldwell to L. Ashby, October 8th. Make sure that Price case gets buried. End of day, preferably Friday. If he misses a deadline, that's his problem. Julian photographed the document and added it to his files. The December hearing was scheduled for 4:45 p.m. on a Friday, exactly as Lorraine Ashby had arranged. By the time Julian entered courtroom 4C, Caldwell had already been on the bench for 8 hours. His patience was visibly frayed. Colbert versus City of Houston. Counsel, this is a status conference. Mr. Hollister? The city is prepared for trial, Your Honor. We've produced all required discovery. Julian stood. Your Honor, the plaintiff has received no discovery. The city's production consists of a letter stating that responsive documents are unavailable. Caldwell's eyes narrowed. Mr. Price, the city has complied with its obligations. If documents are unavailable, that's the end of the matter. Your Honor, Texas Rule 215.1 provides for sanctions when a party fails to produce documents that are known to exist. The plaintiff has independent evidence that the body cam footage exists. What evidence? Julian pulled a document from his briefcase. A press release from the Houston Police Department dated March 15th of last year, announcing their new body cam policy. The release states that all officers involved in use of force incidents are required to wear cameras, and that footage is preserved for a minimum of 5 years. He handed the document to the bailiff, who passed it to Caldwell. The judge's face reddened as he read. This doesn't prove that specific footage exists, counsel. It proves that the city's claim of unavailability is inconsistent with their own stated policies, Your Honor. I move for sanctions against the defendant under Rule 215.1. The courtroom went silent. No one moved for sanctions against Grant Hollister, not in Caldwell's court. Caldwell's knuckles whitened around the document. Motion denied. And Mr. Price, I'm warning you, one more frivolous filing, and I will hold you in contempt. Julian didn't flinch. Understood, Your Honor. For the record, I note the court's ruling and respectfully disagree with its characterization of my motion as frivolous. So noted. We're adjourned. The gavel fell. Julian gathered his papers while Hollister smirked across the aisle. Behind him, Raymond sat in his wheelchair, his face a mask of disappointment. He's never going to let us win, is he? Raymond's voice was barely audible. Julian looked at his client, at the legs that would never work again, at the hope that was slowly dying in his eyes. This isn't about winning in his courtroom, Raymond. It's about winning in a different one. What does that mean? Julian closed his briefcase. Trust me, just a little longer. Subscribe now, because the next hearing is going to change everything. January brought the final preparation. Julian spent 2 weeks compiling his documentation into a comprehensive report. 23 audio recordings of court proceedings. 17 cases showing a pattern of disparate treatment. Sanction data from Texas state bar records showing $340,000 in penalties levied against black civil rights attorneys in Caldwell's court over 5 years, compared to $12,000 against white defense attorneys. The numbers were damning. The pattern was undeniable. He encrypted the files and sent them to Judge Emmett Shaw through a secure channel. Shaw's response came 3 days later. Record is complete. Commission hearing scheduled for March 15th, Austin. Prepare for unsealing. Julian read the message 3 times. 3 years of work. 3 years of abuse. 3 years of watching clients suffer while he built his case. It was almost over. But first, there was one more hearing. February 12th, the final hearing in Colbert v. City of Houston. Julian arrived early, his briefcase containing every document he would need. The courtroom was already filling with spectators, word having spread that the Price-Caldwell confrontation was reaching its climax. Raymond and Tamika sat in the front row of the gallery. Raymond's face was set with determination, though Julian could see the fear beneath it. Grant Hollister arrived with 3 associates, a show of force that said the city was taking this seriously. Wade Crenshaw stood by the door, his eyes tracking Julian's every movement. At precisely 9 a.m., Caldwell entered. Be seated. Colbert v. City of Houston, trial setting conference. Mr. Hollister? Your Honor, the city moves for summary judgment. The plaintiff has failed to produce evidence of excessive force or civil rights violations. Julian stood. The plaintiff opposes. We have not produced evidence because the defendant has refused to provide discovery, including body cam footage that we know exists. Caldwell shuffled papers. Mr. Price, we've been over this. The court has ruled on your discovery motions. Yes, Your Honor. The court has denied 7 discovery motions without stating legal basis, in violation of Texas Rule of Civil Procedure 166AA, which requires, Counsel, you will not lecture this court on procedure. Julian continued as if Caldwell hadn't spoken. Furthermore, Your Honor, I call the court's attention to Texas Government Code Section 552.021, which requires public bodies to produce documents upon request. The city's claim that body cam footage is unavailable is contradicted by their own departmental policies. Mr. Price, Caldwell's voice dropped to a dangerous register. You are testing my patience. I'm advocating for my client, Your Honor, which is my ethical obligation under the Texas disciplinary rules of professional conduct. The courtroom was absolutely silent. No one spoke to Caldwell this way. No one. Caldwell's face had gone from red to nearly purple. I'd like to call Sergeant Neil Pemberton as a witness. Hollister shot to his feet. Objection. Sergeant Pemberton isn't on the witness list. Julian pulled a document from his briefcase. He identified himself as a witness during an encounter 2 months ago, Your Honor. I filed an amended witness list within the deadline under Rule 194. I have the filing receipt here. He handed the document to the bailiff. Crenshaw's jaw tightened as he passed it to Caldwell. The judge examined the receipt. His eyes widened slightly when he saw the timestamp proving the filing was within the deadline. This is highly irregular, Counsel. It's procedurally correct, Your Honor. I request the court compel Sergeant Pemberton to testify. Caldwell's hand trembled slightly as he set down the document. Denied. The court finds that the amended witness list was improperly served. Julian's voice remained steady. Your Honor, the certificate of service is attached to the receipt. It shows proper service via email to counsel for the defendant on December 30th. I said denied. The gavel cracked against wood. One more word, and I will hold you in contempt. Julian looked at the judge, at the rage barely contained behind those gold-rimmed glasses, at 28 years of unchallenged authority crumbling before a man who wouldn't back down. He spoke clearly, for the record, for the recordings, for the commission that would hear every word. Your Honor, for the record, I note that the court has denied 17 discovery motions and witness requests from plaintiff's counsel without stating legal basis. This pattern may constitute reversible error under Fifth Circuit precedent. The word pattern hung in the air. Caldwell's face went white. The court finds counsel in direct contempt under Texas Government Code Section 21.002. Julian didn't move. Bailiff, remove Mr. Price from this courtroom. He is remanded to Harris County Jail for 72 hours. Wade Crenshaw moved forward, his face split by a vicious grin. The handcuffs appeared in his hand as if by magic. Julian closed his notebook and slid it into his jacket pocket. The movement was slow, deliberate, visible to everyone in the courtroom. Your Honor, I note for the record that I am being held in contempt for accurately stating the procedural history of this case. Get him out of my courtroom. Crenshaw grabbed Julian's arm, his grip crushing. Julian didn't resist, as the bailiff wrenched his hands behind his back. The handcuffs clicked shut too tight, metal biting into flesh. Crenshaw leaned close, his breath hot against Julian's ear. I told you what was coming, counselor. Julian looked past him, to Raymond sitting in his wheelchair, eyes wide with horror. 72 hours, Raymond. Remember that number? Let's go. Crenshaw shoved Julian toward the door. As they passed through the courtroom, Julian heard Caldwell's voice behind him. In the absence of plaintiff's counsel, the court grants defendant's motion for summary judgment. Case dismissed. Raymond's cry of anguish followed Julian into the hallway. The doors swung shut. Crenshaw didn't take him straight to booking. Instead, the bailiff marched Julian down a side corridor, through a door marked Staff Only, into a concrete stairwell that smelled of old cigarettes and despair. Wrong way to processing, Mr. Crenshaw. Shut up. Crenshaw shoved him against the wall. Julian's shoulder hit concrete hard enough to send pain shooting down his arm. You think you're smart. Crenshaw's face was inches away. You think your little notes and your little speeches are going to change anything? Julian said nothing. Judge Caldwell has friends, Price. Important friends. People who can make your life very, very difficult. Is that what he told you to say? Crenshaw's fist caught him in the stomach. Julian doubled over, gasping, the breath driven from his lungs. That's what I decided to say. Another punch, this one to the ribs. Julian felt something crack. He dropped to one knee, hands still cuffed behind his back, unable to protect himself. 3 years you've been in his courtroom. 3 years of filing your little motions, making your little objections. Crenshaw grabbed his collar and hauled him upright. You know how many lawyers we've broken? Dozens. They all think they're different. They all learn the same lesson. He slammed Julian against the wall again. You're going to spend 72 hours in county lockup. And when you get out, you're going to drop the Colbert case. You're going to close your office. And you're going to leave Houston. Understand? Julian's voice came out in a rasp. No. Crenshaw's eyes widened. What? I said no. For a moment, something like confusion crossed the bailiff's face. Then it hardened into fury. Wrong answer. The next punch caught Julian across the jaw. He tasted blood. The world spun. He sagged against the wall, held up only by Crenshaw's grip on his collar. I can keep this going all day, Price. Nobody comes down here. Nobody cares what happens to contempt cases. Crenshaw's smile was ugly. So, let me ask again. Are you going to drop the case? Julian spat blood onto the concrete floor. When he looked up, his eyes were clear. "Do what you have to do, Crenshaw. It doesn't change anything." The bailiff stared at him. Something in Julian's expression, some absolute certainty, seemed to give him pause. "You're crazy." He released Julian's collar, letting him slump against the wall. "Fine, have it your way. But remember this conversation when you're sitting in that cell." He grabbed Julian's arm and dragged him toward the stairs. "Let's go. Processing's waiting." Julian stumbled along, his ribs screaming, his jaw throbbing, his hands numb from the too tight cuffs. But beneath the pain, something else burned. Crenshaw had just assaulted a federal witness. He'd just added another charge to the pile, and he had no idea. Harris County Jail was everything Julian had expected. The intake process was designed to dehumanize: strip search, orange jumpsuit, photograph, fingerprints. His notebook was confiscated along with his wallet, watch, and phone. The cell was 8 feet by 6 feet, with a metal bunk bolted to the wall and a steel toilet in the corner. No privacy, no dignity, just concrete and bars, and the endless noise of men caged like animals. Julian sat on the bunk and closed his eyes. 72 hours. That was the number he'd given Raymond, the number he'd been working toward for 3 years. In 72 hours, the contempt citation would expire. He would walk out of this jail with documented evidence of judicial abuse, physical assault, and civil rights violations. And then the real work would begin. The second night, a visitor came. Julian was lying on his bunk, staring at the ceiling, when a guard appeared at his cell. "Price, visitor." He didn't move. "Who?" "Some reporter. You want to see her or not?" Julian sat up slowly, his ribs protesting. The bruises from Crenshaw's beating had bloomed overnight, purple and yellow spreading across his torso. "Send her in." The visitor room was divided by thick glass. Corinne Adair sat on the other side, her recorder already running, her notepad open. She was younger than he'd expected, maybe 30, with sharp eyes and the focused energy of someone who had been chasing a story for too long. "Mr. Price, I'm Corinne Adair, Houston Chronicle. I've been investigating Judge Caldwell for 18 months. Julian picked up the phone on his side of the glass. "I know who you are, Miss Adair. You filed Public Information Act requests for courthouse scheduling logs 6 weeks ago." Her eyebrows rose. "You've been following my work?" "I've been doing similar work, just more quietly." She leaned forward. "What do you mean?" Julian considered his words carefully. The commission hearing was 3 weeks away. He couldn't reveal everything, not yet. "Let's just say that what happened in that courtroom yesterday wasn't random, and the 72 hours I'm spending in here, they're going to matter." "How?" "I can't tell you yet, but when I can, you'll be the first to know." Corinne studied him through the glass. Whatever she saw seemed to satisfy her. "I found something in the scheduling logs. Emails between Ashby and Caldwell." Julian's attention sharpened. "What kind of emails?" "Instructions to bury your cases, direct quotes, Third Ward office, end-of-day slots. If he misses deadlines, that's his problem." She paused. "It's pattern evidence, Mr. Price, the kind that could end a career." "When does it publish?" "It doesn't. Not yet." She met his eyes. "I need an on-record source, someone willing to confirm the pattern, someone who's lived it." Julian was silent for a long moment. "Not yet," he finally said. "But soon. Very soon." "When?" 3 weeks. Come to Austin on March 15th. Texas State Capitol, room E2-016. You'll have everything you need." Corinne wrote down the details. "What happens on March 15th? Julian allowed himself a small smile. "Justice." "Pussy." On the third morning, Julian made a phone call. The number was familiar now. Judge Emmett Shaw's direct line. "Mr. Price." Shaw's voice was calm. "I heard about the contempt citation. Are you all right?" "I'm fine, Your Honor." Crenshaw delivered a message. Physical one. A pause. Did you document it? I will as soon as I'm released. Bruises photograph well. Good. The commission hearing is confirmed for March 15th. The unsealing motion is prepared. The Fifth Circuit will be represented by Judge Harrison Meeks. I've briefed him on the situation. And Caldwell? He has no idea, Mr. Price. He thinks he just silenced another troublemaker. He doesn't know you're the one who's been documenting him all along. Julian leaned against the wall of the phone booth. 3 years, Judge Shaw. 23 recordings, 17 cases. $340,000 in sanctions against black civil rights attorneys, and now a contempt citation and physical assault. The record is undeniable. When you present it to the commission, they'll have no choice but to act. Julian looked at the clock on the wall. 18 hours until release. What about Raymond Colbert? His case was dismissed while you were in custody, but that ruling can be challenged. When the commission acts, every case Caldwell touched will be subject to review, including Colbert's. And the city? Once the pattern is public, they'll have 2 choices: settle or face federal civil rights litigation. Given the evidence you've compiled, I expect they'll choose to settle. Julian nodded slowly. Then it's almost over. Almost. Shaw's voice softened. Your brother would be proud, Mr. Price. You've done what he couldn't, what none of us could. Julian's throat tightened. Thank you, Judge Shaw. Don't thank me yet. We still have work to do. The release came at exactly 72 hours. Julian walked out of Harris County Jail into the harsh Houston sunlight, his ribs aching, his jaw still swollen, his suit rumpled and stained. But his eyes were clear. Tamika Colbert's car was parked at the curb. Raymond sat in the passenger seat, his wheelchair folded in the back. Julian approached the window. Mr. Price. Raymond's voice cracked. They dismissed the case. While you were in there. I'm sorry. I know you tried. Julian looked at his client, at the man who had trusted him through months of losses, through sanctions and delays, through the final humiliation of watching his lawyer dragged away in handcuffs. The case isn't over, Raymond. What do you mean? Julian opened the rear door and climbed in. I mean that what happened in that courtroom was the last piece of evidence I needed. 72 hours ago, Judge Caldwell committed judicial misconduct on the record, in front of witnesses, with documentation. He doesn't know it yet, but he just ended his own career. Raymond stared at him. How? 3 weeks from now, in Austin, I'm going to present 3 years of evidence to the Texas State Commission on Judicial Conduct, and when I'm done, Vernon Caldwell will never sit on a bench again. Tamika's hands tightened on the steering wheel. Is that possible? Julian thought of Dion, of the 31 plaintiffs whose cases had been crushed, of the lawyers who had been sanctioned and silenced and driven out of practice. Not just possible, Mrs. Colbert, inevitable. He leaned back against the seat and closed his eyes. Now let's go home. We have work to do. The bruises told a story. Julian stood in front of his bathroom mirror the morning after his release, documenting every mark on his body. His phone camera captured the purple bloom across his ribs, the yellow-green discoloration along his jaw, the raw welts where the handcuffs had cut into his wrists. Each photograph was time-stamped, each injury measured, each angle preserved for the record that would soon end Wade Crenshaw's career. Left side, ribs 7 through 9, consistent with closed-fist impact. He spoke into the voice recorder on his phone, clinical and detached. Right mandible, lateral bruising, consistent with strike from left-handed assailant. Crenshaw is left-handed. Wrist abrasions, bilateral, consistent with handcuffs applied with excessive force. He lowered the phone and studied his reflection. The man staring back at him looked older than 39. The eyes carried weight that hadn't been there 3 years ago, when he'd sat in Judge Shaw's office and signed the appointment order. But those eyes also carried something else now. Something like victory. 3 weeks until Austin, 3 weeks until everything changed. The preparation consumed every waking hour. Julian organized his evidence into a presentation that would leave no room for doubt. 23 audio recordings, each one time-stamped and transcribed. 17 case files showing the pattern of denial and sanction. Statistical analysis from Pacer and Texas State Bar records demonstrating the demographic disparity in Caldwell's rulings. And now, the photographs of his injuries. The final piece. Corinne Adair came to his office on the second day after his release. She carried a messenger bag stuffed with documents and a laptop that had seen better years. I pulled everything from the Public Information Act requests. She spread papers across his desk. Scheduling logs going back 3 years. Email archives between Ashby and Caldwell. Performance reviews for courthouse staff that mention docket management priorities. Julian examined the documents. Each one confirmed what he already knew, but physical evidence carried weight that testimony alone could not. This email chain. He held up a printout. October 8th, Caldwell to Ashby. Make sure that Price case gets buried. Direct instruction from a sitting judge to manipulate court schedules. Corinne's voice carried barely contained excitement. That's obstruction of justice. It's worse than that. Julian set down the paper. It's a pattern. Every case assigned to my office was moved to end-of-day slots within 48 hours of filing, systematically, over 3 years. How did no one notice? People noticed. They just couldn't prove it. He gestured at the documents covering his desk. Now we can. Corinne leaned forward. When this goes public, it's going to be the biggest judicial misconduct story in Texas history. The Chronicle will run it front page, above the fold. National outlets will pick it up within hours. Not yet. Julian met her eyes. The commission hearing is in 3 weeks. If this leaks before then, Caldwell will have time to prepare, to destroy evidence, to coordinate with his allies. You want me to sit on the story of my career? I want you to be there when it breaks. March 15th, room E2.016, Texas State Capitol. You'll have exclusive access to everything, every document, every recording, every piece of evidence. Corinne studied him for a long moment. Why me? You could give this to any outlet in the country. Julian thought about Dion, about the story that had never been told, the injustice that had never been exposed, the life that had ended in silence and despair. Because you've been investigating Caldwell for 18 months, because you understand what's at stake, and because my brother deserves someone who would tell the truth, and he never got it. I won't make that mistake again. Something shifted in Corinne's expression. When she spoke, her voice was softer. I'll be there, Mr. Price, and I'll tell the truth. If you're invested in Julian's fight for justice, subscribe now, because the hearing that's coming will shake Texas to its core. The call with Judge Shaw came on the first Sunday of March, 2 weeks before the hearing. The commission has confirmed 5 members for your case. Shaw's voice was steady through the phone. 3 former judges, 1 law professor, 1 community representative. All have been briefed on the nature of the allegations. Julian sat in his office, the Houston skyline glittering through his window. And Caldwell? He's been notified of the hearing. His attorney filed a motion to dismiss, claiming the complaint lacks specificity. A pause. The commission denied it. They want to hear your evidence. Does he know about the appointment order? No. The seal has held. As far as Caldwell knows, you're just another attorney he silenced. He has no idea you've been documenting him for the Fifth Circuit. Julian looked at the photograph of Dion on his wall. He will soon. The hearing will be public, per commission rules. Press will be present. Cameras allowed with restrictions. Shaw's tone sharpened. Once you unseal that appointment order, there's no going back. Caldwell will know everything. His attorneys will attack your credibility. They'll claim bias, vendetta, entrapment. Let them. Julian's voice was flat. The evidence speaks for itself. I know it does. Just be prepared. Men like Caldwell don't go quietly. They burn everything around them on the way down. Julian thought about the parking garage, about Crenshaw's fists, about the message that had been delivered with bruises and blood. I've already seen what he's willing to burn, Judge Shaw. I'm not afraid. Silence on the line. Then, quietly, your brother would be proud, Julian. What you've done, it matters. Not just for the plaintiffs in Caldwell's court. For everyone who's ever been crushed by a system that was supposed to protect them. Julian's throat tightened. I'll see you in Austin, Judge Shaw. 2 weeks, Mr. Price. 2 weeks. The night before he left for Austin, Julian visited Raymond and Tamika Colbert. Their apartment was small, a ground-floor unit modified for wheelchair access. The walls were bare except for family photographs and a framed certificate from Raymond's former employer, an electrical contractor who had let him go 6 months after the injury. Coffee? Tamika's voice was tired but welcoming. Thank you, Mrs. Colbert. She disappeared into the kitchen. Raymond wheeled himself to the small dining table where Julian sat. You really think this is going to work? Raymond's eyes searched Julian's face. After everything? The sanctions, the contempt, the case getting dismissed? I think that 3 years of evidence doesn't lie. Julian opened his briefcase and pulled out a document. This is a draft of my presentation for tomorrow. I'd like you to read it. Raymond took the paper. His eyes moved slowly down the page, widening as he absorbed what he was seeing. 89% denial rate for black civil rights attorneys. $340,000 in sanctions. He looked up. This is real? All of this? All of it. Documented, time-stamped, ready to present. Tamika returned with coffee. She set a cup in front of Julian, then moved to stand behind her husband, her hands resting on his shoulders. What happens if they don't believe you? Her voice was barely above a whisper. What if Caldwell's friends protect him? Julian met her eyes. Then we keep fighting. We appeal to the Texas Supreme Court. We involve the Department of Justice. We take this to federal court if we have to. He paused. But I don't think it will come to that. The evidence is overwhelming, and the people on that commission, they became judges because they believe in justice. When they see what Caldwell has done, they won't be able to look away. Raymond set down the document. His hand found Tamika's. 3 years. His voice cracked. 3 years you've been building this case, and all that time, we thought we were losing. You were never losing, Raymond. You were helping me win. Tamika's eyes glistened. What about your brother? The document mentions excluding his case to avoid bias, but he's part of this, isn't he? Part of why you did all this? Julian was silent for a long moment. Dion lost his case in Caldwell's court in 2019. Wrongful termination suit against the city. Caldwell denied every motion, granted summary judgment to the defendant. He paused. 3 months later, my brother stepped in front of a metro train. Tamika's hand flew to her mouth. I'm sorry. I didn't know. Most people don't. Julian's voice was steady, but something raw flickered in his eyes. The official record says it was an accident. I know better. Dion lost faith. In the system. In justice. In everything. He looked at the photograph on their wall, a younger Raymond standing proud in work clothes. I started documenting Caldwell 6 weeks after Dion's funeral. I promised myself that what happened to my brother would never happen to anyone else. Raymond's jaw tightened. It won't, Mr. Price. Not after tomorrow. Julian stood and extended his hand. Raymond took it. I'll call you as soon as the hearing ends, whatever happens. We'll be watching. Tamika's voice was fierce. Every minute. Julian nodded and walked to the door. He paused with his hand on the knob. Raymond, Tamika, thank you for trusting me, even when it looked hopeless. He didn't wait for a response. The door closed behind him, and he walked into the Houston night. Tomorrow, everything would change. The Texas State Capitol building rose against the Austin sky like a monument to ambition. Julian arrived at 7:45 a.m., 15 minutes before the hearing room opened. His briefcase contained 3 years of documentation. His laptop held the presentation that would end a career, and his jacket pocket held the notebook that had recorded every timestamp, every denial, every abuse. The marble halls echoed with the footsteps of early arrivals. Lobbyists, staffers, journalists setting up equipment. Room E2.016 was on the second floor, a hearing chamber designed for the Judicial Conduct Commission's most serious cases. Julian had researched its history. Only 12 judges had faced hearings in this room in the past 2 decades. 9 had been removed from office. He intended to make Vernon Caldwell the 10th. The room itself was smaller than he'd expected. A curved table at the front held 5 seats for the commissioners. A witness table faced them, with 2 chairs for the complainant and their counsel. A defense table sat opposite, already occupied by Caldwell and his attorney, a silver-haired partner from Houston's most expensive firm. Caldwell looked smaller out of his robes. 63 years old, in a dark suit and burgundy tie, he could have been any retired executive. But his eyes hadn't changed. They tracked Julian across the room with the cold calculation of a predator. Julian didn't look away. He took his seat at the witness table and opened his briefcase. Behind him, the gallery was filling. Corinne Adair sat in the front row, laptop open, fingers poised over the keyboard. Other journalists flanked her, cameras discreetly positioned. At the back of the room, barely visible, Judge Emmett Shaw sat with folded arms. At precisely 9 a.m., the commissioners entered. 5 people who held Vernon Caldwell's fate in their hands. The chair was a former appellate judge named Patricia Sung, 70 years old, with a reputation for zero tolerance of judicial misconduct. She surveyed the room with sharp eyes before taking her seat. This hearing is convened pursuant to Texas Government Code Chapter 33 to review allegations of judicial misconduct against the Honorable Vernon Caldwell of the 190th District Court, Harris County. Her voice was clear and authoritative. Mr. Price, you filed the initial complaint. Please proceed. Julian stood. His heart was steady. His voice was calm. Commissioners, before I present evidence, I need to disclose something that will change the nature of these proceedings. He reached into his briefcase and withdrew a document sealed with the emblem of the Fifth Circuit Court of Appeals. Caldwell's attorney was already on his feet. Objection. We were given no notice of additional documentation. Commissioner Sung raised a hand. Let him speak, Counselor. Continue, Mr. Price. Julian broke the seal and held up the document. 3 years ago, I was appointed by the Fifth Circuit Court of Appeals as a court-appointed expert witness under Federal Rule of Evidence 706. My assignment was to document potential patterns of judicial bias in Judge Caldwell's courtroom. The room went silent. Caldwell's face drained of color. His attorney's objection died in his throat. Julian read from the document. Pursuant to Federal Rule of Evidence 706, the Fifth Circuit Court of Appeals hereby appoints Julian D. Price, Esquire, as court-appointed expert witness to evaluate and document potential patterns of judicial bias in the 190th District Court of Harris County, Texas. Appointment date, March 3, 2022. Sealed until evidentiary record complete. He set the document on the table. For the past 3 years, every proceeding in Judge Caldwell's courtroom has been recorded, every ruling documented, every pattern analyzed. The seal has been maintained until today because the Fifth Circuit required a complete evidentiary record before disclosure. He looked directly at Caldwell. That record is now complete. Caldwell's attorney found his voice. This is entrapment. This is unconscionable. My client was being surveilled without his knowledge by someone posing as a legitimate attorney. I am a legitimate attorney, Counselor. Julian's voice cut through the objection. I took cases in Judge Caldwell's court. I represented clients. I filed motions. Everything I did was within the bounds of legal practice. The only difference is that I was also documenting what happened. Commissioner Sung leaned forward. Mr. Price, are you telling this commission that the Fifth Circuit has been conducting a parallel investigation of Judge Caldwell? Yes, Commissioner, and I'm prepared to present the findings. She exchanged glances with her fellow commissioners. Proceed. Julian connected his laptop to the room's display system. The first slide appeared on the screen behind the commissioners, a simple bar graph. Over the past 5 years, Judge Caldwell has presided over 217 civil rights cases involving allegations against law enforcement. Of those cases, plaintiffs won 24. That's an 11% success rate. He advanced to the next slide. The state average for plaintiff success in similar cases is 34%. Judge Caldwell's rate is the lowest in Texas, the lowest in the entire Fifth Circuit. Murmurs rippled through the gallery. Corinne's fingers flew across her keyboard. But statistics alone don't prove bias. Julian's voice was measured. They could reflect the quality of cases filed, the strength of evidence, the skill of attorneys. So I looked deeper. The next slide showed a breakdown by attorney demographics. This chart shows motion denial rates in Judge Caldwell's court, sorted by the race of the plaintiff's attorney. White attorneys, 23% denial rate. Black attorneys, 89%. The number hung in the air. 89%. 9 out of every 10 motions filed by black civil rights attorneys were denied, without stated legal basis, without opportunity for appeal. Caldwell's attorney rose again. These statistics are meaningless without context. Motion denial rates reflect the quality of the motions filed, not the bias of the judge. Julian didn't miss a beat. I anticipated that objection, Counselor, which is why I documented individual cases in detail. He advanced to a new slide showing a spreadsheet with 17 rows. 17 cases over 3 years, each one involving a black civil rights attorney, each one showing the same pattern. Discovery motions denied without legal basis, scheduling manipulated to disadvantage the plaintiff, sanctions issued for filings that complied with all procedural requirements. He clicked to an audio player, and each one recorded under Texas Penal Code Section 16.02, which permits one-party consent recording. The first recording played through the room's speakers. Julian's voice, steady and professional. Your Honor, Texas Rule of Civil Procedure 196.1 requires production of all documents relevant to the subject matter. And then Caldwell's voice, sharp with irritation. I said denied, counsel. Move on. The recording ended. Julian advanced to the next one. This is from November 15th, when I requested the body cam footage from Officer Hendricks. Caldwell's voice again. Motion denied. Overly broad. Julian's voice. Your Honor, the motion specifically requests footage from a single officer during a 45-minute window. Caldwell. Are you arguing with the court? Julian. I'm stating the legal standard, Your Honor. Caldwell. $10,000 sanction. Would you like to continue? The recording ended. The silence in the room was absolute. Julian looked at the commissioners. I have 23 recordings like this, each one showing Judge Caldwell denying motions without legal basis, issuing sanctions without the required finding of bad faith, threatening attorneys who attempted to advocate for their clients. He advanced to the email evidence. But the recordings only show what happened in open court. The manipulation went deeper. The email appeared on screen, blown up large enough for everyone to read. From V. Caldwell to L. Ashby, October 8, 2024. Subject, scheduling. Make sure that Price case gets buried. End of day, preferably Friday. If he misses a deadline, that's his problem. Another slide. From L. Ashby to V. Caldwell, October 15th. Per your request, cases from the 3rd Ward office have been moved to end-of-day slots. Julian paused. 3rd Ward office. That's my office. The only civil rights practice operating out of Houston's 3rd Ward. Judge Caldwell wasn't just ruling against me in court. He was coordinating with his clerk to sabotage my cases before they ever reached a hearing. Commissioner Sung's expression had hardened into granite. Mr. Price, do you have documentation of the scheduling patterns you're describing? I do, Commissioner. He pulled up a timeline showing every case assigned to his office over 3 years, with markers indicating when each one was moved to end-of-day slots. Every case was rescheduled within 48 hours of filing. Every single one. The pattern is consistent across 31 separate filings. Caldwell's attorney was on his feet again. This proves nothing. Scheduling is a clerical function. My client cannot be held responsible for it. Your client sent the email, counselor. Julian's voice cut like a blade. His own words. Make sure that Price case gets buried. That's not a clerical function. That's judicial misconduct. The attorney had no response. Subscribe now and stay tuned, because what comes next will determine whether justice survives in Texas. Julian advanced to the final section of his presentation. On February 12th of this year, Judge Caldwell held me in contempt of court for stating the procedural history of a case. I was remanded to Harris County Jail for 72 hours. He pulled up a photograph. His own face, bruised and swollen, stared out from the screen. During my transport to booking, I was assaulted by Bailiff Wade Crenshaw. These photographs were taken 24 hours after my release. The gallery erupted in murmurs. Caldwell's face had gone from pale to ashen. Mr. Crenshaw told me that Judge Caldwell had asked him to deliver a message. He said I should consider my career and warned me about accidents. Julian pulled up the audio recording from the parking garage. This conversation was recorded 3 months before my arrest, when Mr. Crenshaw confronted me in the courthouse parking structure. Crenshaw's voice filled the room. Judge Caldwell asked me to deliver a message. He says you should consider your career. A lot of lawyers burn out young in this line of work. Stress, health problems, accidents. And then Julian's voice. Is that a threat, Mr. Crenshaw? Crenshaw. It's friendly advice. Take it or leave it. The recording ended. Julian looked at the commissioners. Judge Caldwell used his bailiff to threaten and assault an attorney who was documenting his misconduct. He used his clerk to sabotage cases. He used his position to deny justice to plaintiffs, whose only crime was seeking accountability from law enforcement. He paused. And he did all of this while sitting on a bench that is supposed to represent fairness, impartiality, and the rule of law. Commissioner Sung's voice was ice. Judge Caldwell, do you wish to respond? Caldwell rose slowly. 28 years on the bench, hundreds of cases, thousands of rulings, and now, for the first time, he was the one being judged. His attorney tried to speak, but Caldwell waved him off. Commissioners, I have served this court with honor for nearly 3 decades. I have followed the law as I understood it. If some of my rulings were unpopular, that is the nature of judicial work. He gestured at Julian. This man has a vendetta against me. His brother lost a case in my courtroom. His brother took his own life. I am sorry for that loss, truly sorry. But grief does not give him the right to manufacture evidence and make accusations. Julian stood. I excluded my brother's case from the evidentiary record specifically to avoid the appearance of personal bias. Every case I documented involves other plaintiffs, other attorneys, other victims. Dion's case is not part of this presentation. Caldwell's composure cracked. Then why? Why spend 3 years destroying my reputation? Julian's voice was quiet, but carried to every corner of the room. Because 89% of your denials target one demographic group, Your Honor. That's not discretion. That's discrimination. Because you sanctioned black attorneys $340,000 while white attorneys paid $12,000. That's not enforcement of rules. That's punishment for having the wrong skin color in your courtroom. He stepped closer to the commissioner's table. And because Raymond Colbert will never walk again. Because Darnell Washington spent 4 years in prison on fabricated charges. Because Keisha Moore lost her home. Marcus Freeman lost his business, and Janice Tillman lost custody of her children. All in your courtroom. All because you decided that civil rights plaintiffs didn't deserve justice. Caldwell's face contorted. Caldwell's face. I am a servant of the law. You are a disgrace to the law. Julian's voice rose for the first time. You used your position to protect police officers who broke bones and ruined lives. You used your power to silence anyone who tried to hold them accountable, and when I wouldn't be silenced, you had your bailiff beat me in a stairwell. The room was frozen. That's not justice, Judge Caldwell. That's tyranny, and today it ends. The commission recessed for deliberation at 12:17 p.m. Julian sat alone at the witness table, his presentation complete, his evidence submitted. Behind him, the gallery buzzed with whispered conversations. Reporters filed updates on their phones. Corinne Adair approached but didn't speak, just squeezed his shoulder before returning to her seat. Caldwell and his attorney huddled at the defense table, their faces grim. Whatever strategy they'd prepared had been demolished by the weight of documentation. At the back of the room, Judge Shaw caught Julian's eye and nodded once. A small gesture, but it carried the weight of 3 years of work. The hours stretched. At 2:45, a staff member emerged from the deliberation room and announced that the commission would return at 3 o'clock. Julian didn't move. Didn't check his phone. Didn't speak to anyone. He simply sat and waited, his notebook closed on the table in front of him. 3 years of waiting. Another 15 minutes was nothing. At precisely 3 p.m., the commissioners filed back to their seats. Commissioner Sung's face was unreadable as she settled into her chair and arranged papers in front of her. The other commissioners avoided looking at Caldwell. This commission has reviewed the evidence presented by Mr. Price. Sung's voice was formal, precise. We have considered the testimony, the recordings, the documentation of scheduling manipulation, and the photographic evidence of assault. She paused. We find that Judge Vernon Caldwell engaged in a pattern of conduct that violated Canon 3, B, 5 of the Texas Code of Judicial Conduct, which requires judges to perform duties without bias or prejudice. Julian's pen moved across his notebook. 3:02 p.m. Finding of violation. Canon 3, B, 5. Furthermore, we find that Judge Caldwell violated Canon 2A, which requires judges to act at all times in a manner that promotes public confidence in the integrity of the judiciary. She looked directly at Caldwell. Judge Caldwell, you are hereby suspended from judicial duties, effective immediately. A formal recommendation for removal will be submitted to the Texas Supreme Court within 30 days. Caldwell's attorney rose. Commissioner, my client intends to appeal. That is his right. Sung cut him off. But the suspension is immediate and non-negotiable. She turned to the second commissioner, who read from a prepared statement. Additionally, this commission refers the matter of Bailiff Wade Crenshaw to the Harris County District Attorney and the United States Department of Justice for potential criminal prosecution. The evidence of assault and threats, if substantiated, would constitute violations of 18 U.S.C. Section 242, deprivation of rights under color of law, and Texas Penal Code Section 22.01, assault. Julian's pen kept moving, every word recorded, every ruling documented. The third commissioner spoke. This commission further recommends that the Fifth Circuit Court of Appeals issue a judicial notice to all district courts in Texas regarding the documented bias patterns, and we urge the City of Houston and Harris County to engage in settlement discussions with affected plaintiffs whose cases were adjudicated in Judge Caldwell's court. Sung took back the floor. Finally, this commission notes that Court Clerk Lorraine Ashby participated in the scheduling manipulation documented by Mr. Price. We refer her conduct to the Harris County District Clerk's Office for appropriate administrative action. She set down her papers. Judge Caldwell, do you have anything to say before we conclude? Caldwell stood slowly. His face was gray. His hands trembled slightly. I served this court for 28 years. I did what I believed was right. What you believed was right. Sung's voice was cold. Not what the law required. Not what justice demanded. What you believed. She picked up her gavel. This hearing is concluded. The gavel fell. The aftermath came in waves. Reporters surrounded Julian as he exited the hearing room, their questions overlapping into white noise. Corinne Adair shouldered through the crowd and fell into step beside him. Front page tomorrow, above the fold, and the wire services are already running it. Julian didn't slow down. Make sure you get the statistics right. 89% denial rate. 340,000 in sanctions. Already confirmed, multiple sources. She had to jog to keep up with his long strides. What happens now? Settlement negotiations. The city will want to make this go away quickly. And Caldwell? Julian stopped at the top of the Capitol steps. The Austin skyline stretched before him, afternoon sun glinting off glass towers. Caldwell is finished. The Texas Supreme Court will remove him within 90 days. His pension is gone. His legacy is destroyed. He paused. But that's not enough. What else is there? 31 plaintiffs whose cases were corrupted by his bias. They deserve more than a judicial removal. They deserve compensation. Corinne's eyes widened. You're going after the city. The city, the county, and everyone who enabled Caldwell's conduct for 3 decades. Julian's voice was flat. This isn't over until they pay. All of them. 6 months later, Julian stood in the federal courthouse in Houston, surrounded by 31 people who had trusted him when trust seemed foolish. Raymond Colbert was in the front row, Tamika beside him. Behind them sat the plaintiffs from a dozen other cases, men and women who had lost homes, jobs, families, freedom. People who had walked into Vernon Caldwell's courtroom seeking justice and walked out with nothing but despair. The press gallery was packed. Cameras lined the walls. Corinne Adair had a reserved seat, her credential badge identifying her as lead reporter on what the Chronicle was calling the Caldwell investigation. Julian approached the podium. 6 months ago, the Texas State Commission on Judicial Conduct found that Judge Vernon Caldwell engaged in systematic bias against civil rights plaintiffs in his courtroom. Today, we announce the resolution of that misconduct. He unfolded a document. The City of Houston and Harris County have agreed to a collective settlement of $52 million to be distributed among 31 plaintiffs whose civil rights cases were affected by documented judicial bias. Gasps rippled through the crowd. Raymond's hand found Tamika's and squeezed. This represents the largest civil rights settlement in Texas history. It acknowledges what the evidence has proven, that for nearly 3 decades, a single judge corrupted the pursuit of justice for hundreds of plaintiffs. That systematic bias infected every level of the Harris County court system, and that the victims of that bias deserve not just vindication, but compensation. He set down the document. But money cannot undo what was done. Raymond Colbert will never walk again. Darnell Washington lost 4 years of his life to a wrongful conviction. Keisha Moore's children grew up without their mother. No settlement can give them back what was taken. He looked at the plaintiffs. What this settlement represents is accountability. It represents acknowledgement that the system failed, and it represents a promise that such failure will not be tolerated again. The press conference dissolved into questions, but Julian stepped back from the podium. He'd said what needed to be said. The details could come from the lawyers handling distribution. Raymond wheeled himself forward, navigating through the crowd until he reached Julian. $52 million. His voice was hoarse. I never thought I'd see anything like this. You earned it, Raymond. All of you did. No. Raymond shook his head. You earned it. 3 years of your life. Everything you went through. The sanctions, the jail, the beating. His eyes glistened. You never gave up. Even when we did. Julian looked at the man in the wheelchair, at the faith that had somehow survived everything Caldwell had done to destroy it. I made a promise, Raymond, to my brother, to myself, that what happened to him would never happen to anyone else. He paused. I couldn't save Dion, but maybe I saved some of you. Tamika appeared beside her husband, tears streaming down her face. You saved all of us, Mr. Price. Every single one. The outcomes unfolded over the following weeks. Vernon Caldwell resigned before the Texas Supreme Court could formally remove him. His pension was forfeited under a provision that denied benefits to judges removed for misconduct. At 63, he faced the prospect of returning to private practice, but no firm would touch him. The last anyone heard, he was living in a rental apartment in Galveston, refusing all interview requests. Wade Crenshaw, was indicted by a federal grand jury on charges of deprivation of rights under color of law, 18 U.S.C. Section 242. The trial was scheduled for January. If convicted, he faced up to 10 years in federal prison. His union provided a lawyer, but the evidence was overwhelming. Plea negotiations were reportedly ongoing. Lorraine Ashby was terminated from her position as court clerk. The Texas State Bar opened an investigation into whether her conduct constituted obstruction of justice. She hired a criminal defense attorney and stopped answering her phone. Grant Hollister, the city's lead attorney in civil rights cases, received notification that the State Bar of Texas was investigating whether he had knowledge of Caldwell's bias pattern and failed to report it. His status was listed as under review. His firm issued a statement expressing full confidence in his integrity. No one believed it. Sergeant Neil Pemberton was placed on administrative leave pending an internal affairs investigation into his threatening encounter with Julian at the coffee shop. The outcome remained pending, buried in departmental bureaucracy. The Fifth Circuit Court of Appeals issued a judicial notice to all district courts in Texas, warning of the documented bias patterns and urging enhanced oversight of civil rights cases. It wasn't binding precedent, but it was a signal. The federal courts were watching. Raymond Colbert's case was reopened in a different court, assigned to a judge who had read the commission report and understood its implications. The outcome remained pending, but for the first time in 3 years, Raymond allowed himself to hope. But not every question had an answer. Julian sat in his office on a Thursday evening, reviewing the settlement documents, when a manila envelope arrived by courier. No return address, no identifying marks.
Inside was a single document, a printout of an email chain between Caldwell and an address listed only as at houstonpba.org, Houston Police Benevolent Association. The email bodies were completely blacked out, 37 pages of redactions, with only the headers visible, dates spanning 5 years, subject lines that read RE Case Assignments and RE Coordination and RE Quarterly Review. A post-it note was stuck to the first page, handwritten in block letters, "You found one. There are more." Julian stared at the document for a long time. Caldwell hadn't acted alone. Someone in the police union had been coordinating with him, someone who was still out there, still protected, still redacting evidence. He opened his notebook and wrote, October 15th, 2025.
Anonymous document received. Police union connection confirmed. 37 pages redacted. Investigation ongoing. The wall wasn't finished. It was just beginning. A week later, a young man walked into Julian's office. He was 24 years old, tall and thin, with the nervous energy of someone who had rehearsed what he was going to say 100 times. "Mr. Price, I'm Malik Odom. I just graduated from Thurgood Marshall School of Law." Julian looked up from his desk. "I know who you are, Mr. Odom. You were 3rd in your class. Law Review, moot court champion." He gestured to the chair across from him. "What can I do for you?" Malik sat down, his knee bouncing with suppressed energy. "I read about your case, the Caldwell investigation, the settlement." He leaned forward, "I want to work for you." "I don't have an internship program." "Then hire me. I'll work for free until you can afford to pay me." Julian studied the young man's face, the determination, the hunger, the absolute certainty that this was where he belonged. "Why civil rights law? You could make 10 times more at a corporate firm with your credentials." Malik's jaw tightened. "Because my father was arrested on fabricated charges when I was 12. Because he spent 18 months in county jail waiting for a trial that kept getting delayed. Because when he finally got out, he couldn't find work, couldn't get housing, couldn't rebuild his life." He paused. "The charges were eventually dismissed, but by then, our family was destroyed." Julian said nothing. "I went to law school because I wanted to make sure what happened to my father didn't happen to anyone else." Malik's voice steadied. "Sound familiar?" Julian thought of Dion, of Raymond, of the 31 plaintiffs whose lives had been upended by a single biased judge. "You understand what this work involves? The hours? The defeats? The system that will fight you every step of the way. I understand. And you still want to do it? Malik met his eyes without flinching. I'd rather be poor and useful than rich and complicit. Julian was silent for a long moment. Then he gestured to the empty desk in the corner of his office, the one that had been gathering dust for 3 years. That desk belonged to my brother. He worked here before his case, before everything fell apart. He paused. It's yours if you want it. Malik's face broke into a smile. Thank you, Mr. Price. You won't regret this. Don't thank me yet. Julian slid a stack of files across his desk. These are the 37 pages of redacted emails. Somewhere in there is evidence of a connection between Vernon Caldwell and the Houston Police Benevolent Association. Find it. Malik picked up the files, his expression shifting from gratitude to determination. How long do I have? However long it takes. Julian turned back to his computer. Welcome to the fight, Mr. Odom. Subscribe and turn on notifications, because Julian's next case is going to blow this story wide open. On a Sunday morning in late October, Julian drove to Houston Memorial Gardens. The cemetery was quiet, dew still glistening on the grass. He parked in the visitor's lot and walked the familiar path to Section E, Row 14, Plot 7. The headstone was simple. Gray granite. Name, dates, a single line of epitaph. Dion Marcus Price, 1991-2019. Beloved brother. Seeker of justice. Julian stood before the grave, hands in his pockets, the morning sun warm on his face. He didn't speak for a long time. There was too much to say, and no words that seemed adequate. Finally, he pulled out his notebook. The same one he'd carried for 3 years. The one that held every timestamp, every denial, every piece of evidence that had brought Vernon Caldwell down. He opened it to the last page and wrote, October 26, 2025. Commission hearing. Success. Settlement. 52 Nellis Caldwell. Resigned. Caldwell. Crenshaw. Indicted. Dion. I hope this is enough. I hope you can rest now. He read the words aloud, his voice barely above a whisper. I couldn't save you. I couldn't stop what happened. But I could make sure it mattered. That your case, your pain, your death, wasn't for nothing. He closed the notebook. The fight isn't over. There are more like Caldwell out there. More judges, more cops, more people who think they're above the law. He paused. I'm going to find them. All of them. And I'm going to bring them down. A bird sang somewhere in the trees. The wind rustled through the grass. Malik started this week. He reminds me of you, a little. The same fire. The same refusal to give up. Julian allowed himself a small smile. I think you'd like him. He reached into his pocket and pulled out a single flower. A white rose, Dion's favorite. He laid it on the grave. Rest now, little brother. I've got it from here. He stood for another moment, memorizing the headstone, the grass, the way the light fell through the trees. Then he turned and walked back to his car. There was work to do. That night, Julian was reviewing case files in his office when his phone rang. The caller ID showed an Austin area code. 512. He answered on the third ring. Mr. Price? The voice was older, authoritative, unfamiliar. This is Chief Justice Nathan Harlow, Texas Supreme Court. Julian set down his pen. Chief Justice, how can I help you? I've reviewed your work on the Caldwell matter, the commission report, the settlement, the documentation. A pause. Impressive work, Mr. Price. Thorough, methodical, the kind of work that changes systems. Thank you, sir. I'm calling because we've identified similar patterns in 2 other district courts, Dallas and San Antonio. Denial rates that deviate significantly from state averages. Sanction patterns that suggest demographic targeting. Another pause. The Judicial Conduct Commission doesn't have the resources to investigate both simultaneously. We need someone with experience. Julian looked at the stack of files on his desk, at the redacted emails still waiting to be decoded. At Malik's empty desk, the young man having gone home hours ago. "You're asking me to expand my work." "I'm asking you to continue what you've already started." The Caldwell case proved that documentation works, that evidence matters, that even the most entrenched misconduct can be exposed if someone is willing to do the work. Julian thought about Dion, about the promise he'd made at his brother's grave. Dallas and San Antonio. How bad? Dallas is worse than Caldwell. Plaintiff success rate of 8% in civil rights cases. San Antonio is more subtle, but the sanction patterns are unmistakable. Julian picked up his pen. "Send me the data, everything you have. Case numbers, judges' names, timeline. I'll have it to you by morning." The Chief Justice's voice warmed slightly. "Mr. Price, I won't pretend this will be easy. You made enemies with the Caldwell case. Powerful enemies. What you're proposing will make more." "I know." "And you're still willing?" Julian looked at Dion's photograph on the wall, at the notebook that had recorded 3 years of injustice, at the city of Houston glittering through his window, full of people who deserved better than they were getting. "I'm listening, Chief Justice." "Then we have work to do, Mr. Price." The call ended. Julian sat in silence for a moment, absorbing the weight of what he'd just agreed to. 2 more investigations. 2 more years, maybe 3. 2 more battles against systems that would fight him every step of the way, but also 2 more chances to keep his promise. 2 more judges who would face accountability. 2 more courtrooms where justice might finally prevail. He opened his notebook to a fresh page and wrote, "October 26, 2025, 9:47 p.m., Chief Justice Harlow, Dallas and San Antonio patterns confirmed, investigation authorized." Then he added one more line, "The work continues." He closed the notebook and looked out the window at the Houston night. Somewhere in the city, Wade Crenshaw was awaiting trial. Somewhere, Lorraine Ashby was answering questions from investigators. Somewhere, 31 plaintiffs were rebuilding lives that had been shattered by a corrupt judge. And somewhere, in a cemetery on the edge of town, Julian Price rested beneath a headstone that read, "Seeker of Justice." Julian had sought it for both of them. And he wasn't done yet. In his office, the desk lamp cast long shadows across stacks of files and legal documents. Malik's desk sat waiting in the corner, ready for tomorrow. The photograph of Dion watched over everything, frozen in a moment before the darkness came. Julian reached for his coffee, found it cold, and drank it anyway. Outside, Houston hummed with the restless energy of a city that never truly slept. Sirens in the distance, traffic on the freeway, the endless rhythm of 10 million lives intersecting, colliding, seeking something that felt like fairness in a world that offered none by default. His phone buzzed. A text from Malik. "Found something in the redactions. Call me in the morning." Julian smiled. The 37 pages were starting to talk. He stood, stretched muscles stiff from hours of sitting, and walked to the window. The skyline blazed against the darkness, a testament to human ambition and human failure in equal measure. Somewhere out there, another Vernon Caldwell sat on another bench, issuing another ruling designed to crush another plaintiff who had dared to seek justice. Somewhere, another Wade Crenshaw delivered another threat in another parking garage. Somewhere, another family watched their hopes die in a courtroom that was supposed to protect them. Julian couldn't save them all. He knew that. But he could save some, and some was better than none. He turned off his desk lamp, gathered his coat, and headed for the door. Tomorrow would bring new cases, new challenges, new battles against a system that fought change with every weapon at its disposal. He was ready. The door closed behind him with a soft click. Outside, the Houston night was vast and full of possibility, and Julian Price walked into it alone, carrying the weight of his brother's memory and the promise of justice still to come. The federal courthouse in Dallas was larger than the one in Houston, its marble corridors echoing with the footsteps of attorneys and plaintiffs and journalists who had come to witness history repeat itself. Julian stood at the plaintiff's table, his briefcase open, his presentation ready. Beside him sat Malik Odom, no longer the nervous law school graduate who had walked into his office 18 months ago. The young man had grown into a formidable attorney in his own right, his research skills honed by countless hours spent decoding redacted documents and tracing patterns through mountains of data. Across the aisle, Judge Harlan Whitfield's defense team shuffled papers with the desperate energy of people who knew they were losing. Commissioner Patricia Sung, the same woman who had presided over Caldwell's hearing, took her seat at the head of the panel. This commission is convened to review allegations of judicial misconduct against the Honorable Harlan Whitfield of the 162nd District Court, Dallas County. Her voice carried the weight of someone who had done this before and expected to do it again. "Mr. Price, please proceed." Julian rose. "Commissioners, 18 months ago, I presented evidence that Judge Vernon Caldwell of Harris County had engaged in systematic bias against civil rights plaintiffs. Today I present evidence of an identical pattern in Judge Whitfield's courtroom." He advanced to the first slide. Plaintiff success rate in civil rights cases, 7%. State average, 34%. Sanction rate against black attorneys, 91%. Against white attorneys, 18%. The numbers landed like hammer blows. The pattern is not coincidence, commissioners. It is policy. The Dallas investigation had taken 14 months to complete. Julian and Malik had worked in shifts, one of them always at the office, always reviewing transcripts, always adding data to the spreadsheet that had grown from hundreds of rows to thousands. They had taken cases in Whitfield's court, documented every denial, recorded every proceeding. The pattern was even worse than Caldwell's. Whitfield didn't just deny motions without legal basis. He actively coached defense attorneys during proceedings, feeding them objections, suggesting arguments, steering cases toward predetermined outcomes. His court reporter had been falsifying transcripts for years, removing his most egregious statements from the official record. But Julian had his own recordings, 29 audio files, 43 cases, a paper trail that connected Whitfield to the Dallas Police Association through a series of campaign contributions that had never been properly disclosed, and one witness who had agreed to testify. The commission calls Maria Santos. A woman in her 50s approached the witness table, her hands trembling slightly as she took her seat. For 12 years, she had been Judge Whitfield's court reporter. For 12 years, she had altered transcripts at his direction. 3 months ago, she had walked into Julian's office with a flash drive containing the original, unaltered recordings of every proceeding she had documented. "Ms. Santos, please describe for the commission the instructions you received from Judge Whitfield regarding transcript preparation." Maria's voice was steady despite her obvious fear. "He told me to clean things up, to remove any statements that might look bad on appeal." She paused. "Specifically, he told me to delete any comments he made that suggested he had predetermined the outcome of a case." "And did you follow these instructions?" "For 12 years, yes." "Why are you coming forward now?" Maria looked at Julian, then at the commissioners, then at Judge Whitfield, whose face had gone the color of old paper. "Because my grandson was arrested last year. Traffic stop. The officers claimed he resisted. He didn't. I saw the video. But the case was assigned to Judge Whitfield's court, and I knew—" Her voice broke. "I knew what would happen. I knew my grandson would lose, no matter what the evidence showed. Because that's how Judge Whitfield's court works." She straightened in her chair. "I couldn't be part of it anymore. Not when it was my own family." The commission deliberated for 4 hours. When they returned, Commissioner Sung's face was grim. "This commission finds that Judge Harlan Whitfield engaged in systematic misconduct, including falsification of court records, ex parte communications with defense counsel, and deliberate bias against civil rights plaintiffs." Julian's pen moved across his notebook, recording every word. "Judge Whitfield is hereby suspended from judicial duties, effective immediately. This matter is referred to the Texas Attorney General for potential criminal prosecution. Additionally, we recommend that all civil rights cases adjudicated in Judge Whitfield's court over the past 15 years be reviewed for potential retrial." 15 years, hundreds of cases, thousands of plaintiffs who had been denied justice by a system designed to crush them. The gavel fell. Julian closed his notebook and looked at Malik. One down, one to go. If you've followed Julian's fight this far, subscribe now, because the San Antonio case is about to reveal something no one expected. San Antonio was different. The pattern there was subtler, harder to prove. Judge Carmen Reyes didn't deny motions outright or coach defense attorneys. Instead, she manipulated procedure, using scheduling delays and discovery disputes to exhaust plaintiffs until they gave up. Cases in her court took 3 times longer than the state average to resolve. Plaintiffs ran out of money, out of patience, out of hope. They accepted settlement offers that were fractions of what they deserved, or they simply walked away. It was death by 1,000 cuts, and it was almost impossible to document. Almost. Malik had found the key buried in the 37 pages of redacted emails that had arrived anonymously 18 months earlier. The police union connection isn't just Caldwell. He spread printouts across Julian's desk, his eyes bright with the excitement of discovery. It's statewide: Houston, Dallas, San Antonio. They're all connected through something called the Texas Law Enforcement Judicial Alliance. Julian studied the documents. TLEJA. I've never heard of it. That's because it doesn't officially exist. It's not registered as a non-profit, not listed as a PAC, not documented anywhere in public records. Malik pointed to a series of bank transfers. But money flows through it. Campaign contributions to judges, payments to court staff, consulting fees to attorneys who handle police defense cases. Where did you get this? I traced the routing numbers from the redacted emails. The redactions blacked out the content, but they left the headers intact. Transaction dates, amounts, account identifiers. Malik smiled grimly. Whoever sent us those documents wanted us to find this. They just couldn't give it to us directly. Julian looked at the web of connections spreading across the printouts. 3 cities, 3 judges, dozens of attorneys, clerks, and union officials. A conspiracy to corrupt the civil rights legal system across an entire state. This is bigger than Caldwell, bigger than Whitfield. It's bigger than Texas. Malik pulled out another document. I found similar patterns in Louisiana, Oklahoma, and New Mexico. Same statistical anomalies, same demographic targeting, same invisible money flows. Julian sat back in his chair. We need federal help. I already made the call. Malik's voice was quiet. DOJ Civil Rights Division. They want to meet. 3 weeks later, Julian sat in a conference room at the Department of Justice headquarters in Washington, D.C. Across the table, Assistant Attorney General Denise Crawford reviewed the documentation he had provided. She was 52 years old, a career prosecutor who had spent 2 decades building civil rights cases against local governments and law enforcement agencies. Mr. Price, what you're describing is a multi-state conspiracy to deny constitutional rights through judicial corruption. Her voice was carefully neutral. Do you understand the implications of that allegation? I understand that the evidence supports it. Evidence you gathered as a court-appointed expert witness for the Fifth Circuit. Initially, yes, the Dallas and San Antonio investigations were conducted independently at the request of the Texas Supreme Court. Crawford set down the documents. We've been aware of statistical anomalies in civil rights case outcomes for years. We've suspected coordination between police unions and sympathetic judges, but we've never been able to prove it. She paused. Until now. Julian waited. The Department of Justice is opening a pattern or practice investigation into judicial corruption in Texas, Louisiana, Oklahoma, and New Mexico. We're assigning a task force of 12 attorneys and 20 investigators. She met his eyes. We'd like you to serve as a consultant. Julian thought about his office in Houston, about Malik, who had grown from student to partner, about the cases still waiting on his desk, the plaintiffs still seeking justice in courtrooms across the state. I have conditions. Name them. First, Raymond Colbert's case. It was reopened after the Caldwell settlement, but it's been stuck in procedural limbo for 18 months. I want it prioritized. Crawford nodded. Second, Wade Crenshaw. His trial has been delayed 4 times. I want DOJ to take over the prosecution. That can be arranged. Third, the anonymous source who sent me the redacted emails. Whoever they are, they're still inside the system. They're still at risk. I want protection for them if they're ever identified. Crawford was silent for a moment. You don't know who sent those documents? No, but I know they saved this investigation. Without those emails, we never would have found Talijah. We never would have connected the 3 judges. We never would have understood the scope of what we were fighting. Crawford picked up her pen. Agreed. All 3 conditions. She extended her hand. Welcome to the task force, Mr. Price. The DOJ investigation took 2 years to complete. In that time, Julian traveled to 14 cities across 4 states. He reviewed thousands of documents, interviewed hundreds of witnesses, and built cases against 9 judges, 37 attorneys, and 12 police union officials. Malik ran the Houston office in his absence, taking cases, training new attorneys, building the practice into something that would survive long after Julian was gone. The Texas Law Enforcement Judicial Alliance was exposed in a joint press conference between DOJ and the Attorneys General of 4 states. 17 indictments were announced on a single day. 3 judges resigned before they could be removed. 2 fled the country. And Vernon Caldwell, watching from his rental apartment in Galveston, saw his legacy transformed from isolated misconduct into the tip of a corrupt iceberg. Wade Crenshaw's trial took place in federal court in Houston 3 years after the assault in the courthouse stairwell. Julian sat in the gallery, watching as the prosecutor presented the evidence he had gathered, the photographs of his injuries, the audio recording from the parking garage, the testimony of the jail intake officer who had noticed the fresh bruises when Julian arrived. Crenshaw's defense was simple. Julian had fallen. The injuries were an accident. There was no assault. The jury deliberated for 6 hours. When they returned, the forewoman's voice was clear. On the charge of deprivation of rights under color of law, we find the defendant guilty. Crenshaw's face went blank. His attorney's hand fell on his shoulder, but he didn't seem to feel it. On the charge of assault, we find the defendant guilty. The judge scheduled sentencing for the following month. When it came, Crenshaw received 7 years in federal prison. Julian watched them lead him away in handcuffs, the same handcuffs that had once been used on him. He felt nothing. Justice wasn't about vengeance. It was about accountability. And accountability had finally come. Raymond Colbert's case was retried in federal court, removed from the Texas state system entirely. The evidence that Caldwell had suppressed was finally presented, body cam footage showing the officers striking Raymond without provocation, internal affairs records documenting previous complaints against the same officers, medical testimony linking his injuries directly to the assault. The jury awarded Raymond $14 million in damages. It wouldn't give him back his legs. Nothing could do that. But it gave him and Tamika security for the rest of their lives. It gave them the resources to adapt their home, to hire help, to live with dignity instead of desperation. When the verdict was announced, Raymond wept. Julian sat beside him, silent, his hand on Raymond's shoulder. You did it. Raymond's voice was barely audible. After everything, you did it. We did it, Raymond. Together. On the 5th anniversary of Dion's death, Julian returned to Houston Memorial Gardens. The cemetery was quiet, the same as always. He walked the familiar path to Section E, Row 14, Plot 7. The headstone hadn't changed. Gray granite, name, dates, epitaph. Dion Marcus Price, 1991-2019. Beloved brother, seeker of justice. But Julian had changed. He was 44 now, gray threading through his hair, lines carved into his face by 5 years of fighting. He had won victories he once thought impossible and lost battles he had expected to win. He had built something that would outlast him and destroyed systems that had seemed invincible. And he had kept his promise. He knelt beside the grave, his hand resting on the cool stone. It's been 5 years, little brother. 5 years since I made you a promise. The wind stirred the trees. A bird sang somewhere in the distance. Caldwell is gone. So is Whitfield. So is Reyes. 9 judges in 4 states, removed from the bench or resigned in disgrace. T-Legia is dismantled. The DOJ has consent decrees in place across the Southwest. He paused. Crenshaw is in prison. Raymond got his verdict. 31 plaintiffs received compensation. Hundreds of cases are being reviewed. He closed his eyes. I couldn't save you. I couldn't undo what happened. But I could make sure your death meant something. That the system that killed you would never kill anyone else the same way. The tears came then, quiet and unexpected. He had held them back for 5 years, channeling his grief into work, into documentation, into the relentless pursuit of justice. But here, alone with his brother's memory, he finally let them fall. I miss you, Dion, every day. I miss your laugh and your stubbornness and the way you never gave up on anything. I miss arguing with you about cases. I miss having dinner together on Sundays. He wiped his eyes with the back of his hand. But I carry you with me, in every case I take, in every courtroom I enter, in every fight I refuse to walk away from. He stood slowly, his knees protesting the cold ground. Malik is a partner now, full partner, not just an associate. He's better than I was at his age. He's going to do great things. He smiled. I think you'd like him. He has your fire. He reached into his pocket and pulled out a white rose, the same flower he brought every year. Rest now, little brother. The work continues. But you can rest. He laid the rose on the grave and stepped back. The sun was setting over Houston, painting the sky in shades of orange and gold. Julian watched the light fade, feeling the weight of 5 years lift slightly from his shoulders. The fight wasn't over. It would never be over, not entirely. There would always be another Caldwell, another Whitfield, another system designed to crush people who dared to seek justice. But there would also always be people willing to fight. Attorneys like Malik, who chose purpose over profit. Witnesses like Maria Santos, who found courage when it mattered most. Plaintiffs like Raymond Colbert, who refused to give up even when hope seemed foolish. And there would always be people like Julian Price, carrying the memory of those they had lost, channeling grief into action, transforming pain into purpose. The last light faded from the sky. Julian turned and walked back to his car, leaving the white rose behind. Tomorrow would bring new cases, new challenges, new battles. He was ready. 6 months later, Julian received a letter. It arrived at his office with no return address, postmarked from Austin. Inside was a single sheet of paper, handwritten in careful script. Mr. Price, I was the one who sent you the redacted emails 5 years ago. I worked in the Harris County District Clerk's office for 23 years. I watched Caldwell destroy people for most of that time. I was too afraid to speak up. When you started documenting him, I knew you were different. You weren't going to give up. You weren't going to be silenced. So I helped the only way I could. I'm retired now, living somewhere warm. The DOJ offered me protection, like you asked, but I didn't need it. Nobody ever suspected me. I just wanted you to know what you did mattered, not just for the plaintiffs, not just for the attorneys, for everyone who ever walked into a courtroom hoping for justice and walked out with nothing. You gave us hope. Thank you. A friend. Julian read the letter 3 times. Then he folded it carefully, placed it in his desk drawer, and went back to work. The fight continued. It always would. Julian Price's story is not merely about one lawyer's battle against a biased judge. It is a lesson about the power of patience, the importance of documenting every detail, and the belief that justice, however delayed, can still prevail. Julian did not win through eloquence or luck. He won through 3 years of meticulous record-keeping, every timestamp, every statement, every violation. In a system designed to protect the powerful, evidence is the one thing that cannot be dismissed. Julian accepted losing cases, endured financial sanctions, suffered physical assault, and spent time in jail, all to build his evidentiary record. Sometimes, long-term victory requires accepting short-term defeat. Julian lost his brother to an unjust system. Rather than letting that grief destroy him, he transformed it into the driving force to change that system for others. No victory is perfect. Caldwell resigned, but was never arrested. The settlement was signed, but redacted emails remained unexplained. True justice is not an ending. It is an ongoing process of continuous struggle. Ultimately, this story reminds us that an ordinary person with extraordinary persistence can shake a system that once seemed untouchable. The fight for justice is never finished, but every small victory builds the foundation for the next.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.